And thank you for joining me. My name is Maria Madrid. I'm the Director of Latino Services at the Colorado Gerontological Society. And today we'll talk about advance directives or doctor's orders. Thank you very much for joining me. This is part of our advanced care planning webinar series. And today we're going to dive further into advance directives and how your situation impacts what advance directives you choose. One of the things that I want to make sure we do today is provide you with best practices, information to help you through your advanced care planning journey. So feel free to ask any questions using either the Q&A or the chat. As I go through the topic, I will check on those on a regular basis. Also, this session is being recorded. I will make it available to everyone in addition to the slides that we're covering today. The other thing that I will do so you are able to see the whole screen is turn off my camera so you're able to see all the images and all the information that I've provided to you. So let's get started. So the first thing is, this is part of a webinar series. The information that I'm discussing is Colorado specific. Why do I make this distinction? Because every state has their own rules and regulations. The concepts are similar, but I want to make sure that you understand that this is specific to Colorado. The Society provides assistance to complete your advance directives at no cost. So please, if you need assistance with them, we're happy to help. At the end of the presentation, I will provide you with my contact information. Also, I will provide you resources as well as access to all the forms. They could be found on our website, senioranswers.org. And when we're talking about advanced care planning, we're talking about everyone over the age of 18. Although the Society focuses on older adults, the information that we're covering today is for everyone 18 and over. So my objectives for you today are for you to consider what advance directives you need in order for you to create your own advanced care plan. We're going to go into advance directives and really dive into, are they better than doctor's orders? What's the difference between doctor's orders and advance directives? And which ones should I have and which ones are right for me based on my situation. And really focusing on your circumstances, that's really going to allow you to understand what forms you need to have and to clarify, because there's quite a few of advance directives. Some advance directives are not doctor's orders, so there's a lot of confusion. So my goal today is for you to walk away with understanding that there's different tools and what tools do you need for your situation. So at the Society, we take advanced care planning in a very holistic approach. Today we're considering the medical, and we're talking about the medical. So far in our webinar series, we have focused in this area. Future webinars will focus on the financial and legal aspects. So please join us so we could talk about advance directives to help you in finances and also legal. So let's talk about what advance directives are available. So let's start with what is the difference and why do we care about making this distinction? So think of all of the different forms that we're going to talk about today. They're under the umbrella of advance directives. However, some of them are legal documents, and some of them are doctor orders. So what they do in their and what they're meant for is very different, and how they impact the medical treatment that you receive is also based on whether they're a legal document or a doctor's order. So all the documents that we're talking about today are under the umbrella of Advance Directives, but they're either a legal document or a doctor's order. So the reason why we want to make that distinction is to understand what each tool does. So we could ensure that as we're considering what documents I need to have, what advance directives, that you're using the right one for you, and you don't void other documents, or you don't set yourself up for unintended consequences. We want to go ahead and make sure that that is not happening as you're going through your advanced care planning journey. So we'll also cover the additional implications that doctor's orders have when it comes to medical treatment, and really focus on creating bridges of access and removing those barriers to any preferred care that you have in case that you become incapacitated. So let me take a step back and talk about basically the requirements of who should be completing any medical advance directives. So once again, advance directives are different legal documents that allow everyone ages 18 and over to make decisions about future medical care in the event that they, for whatever reason, whether it's a accident or a medical crisis, they become unable to communicate their needs and they need medical care. Also, Colorado is not a next of kin state. So what does this mean, and how does this impact me, right? So this means that everyone who is an adult that is 18 years and over needs to have advance directives to allow someone of their choice to speak on their behalf. If they become incapacitated, if they have a medical crisis, car accident, whatever have you, where they need medical care and they can't communicate their needs. So once again, it's for everyone 18 and over, and only those that have decisional capacity should complete advance directives. If individuals do not have decisional capacity, this means that advance directives are not a document that they should be completing, and their family, loved ones, their support system should be looking at legal guardianship, conservatorship to support those individuals. So decisional capacity means you have the ability to provide informed consent or the refusal of medical treatment, or the ability to make informed healthcare benefit decisions. So this means you have the cognitive capacity to take that information and make a decision about the medical care that you want. Those are the individuals that should be completing advance directives. And we want to make sure that the advance directives, we're completing them well before there is an issue, so that way we have a plan in place. We have spoken to the individuals that we need to speak to ensure that we know what's going to happen in case of an emergency. So let's begin with the most talked about document, and the one that personally I recommend that everyone over the age of 18 has. So the medical durable power of attorney, this is a legal document. It doesn't matter what your health level is, you should have it as part of your advance directives. So what does a medical durable power of attorney do? It appoints who is going to speak on your behalf, who's going to make medical decisions for you in the event that you need medical care and cannot communicate. Your medical durable power of attorney does this. No other advance directive does this. This is why I say that it's one of the most important advance directives that anyone should have. So the form that I will provide for you, it's a fill in the blank form, and it is very commonly used in Colorado. However, know that there's many medical durable power of attorney forms. So the one that I'm providing to you today, this form is fill in the blank. However, many individuals go to their attorney to get it completed. So essentially, it's going to look very different than the one that I'm providing to you. So if you are going to an attorney, the attorney is going to customize that medical durable power of attorney. And in addition to documenting who's going to speak on your behalf, it might have some additional items. So make sure that you fully understand what that medical durable power of attorney says if you are going to an attorney in that way. When you're talking to your agent and your alternates, they understand what the document has and that they have a copy. So let's talk about agents. So your agent is the person that is going to speak on your behalf, and your alternates are folks that, in the event that for whatever reason your agent is not able to speak on your behalf, they're able to step in. So think about plan A being your agent, and your alternates are your plan B and C. So the form that I'm providing for you has the ability to add 2 alternate agents. If you're going to a attorney, you could have more than 2, and so on and so forth. So as you are planning what makes sense for you and what you want your medical durable power of attorney to look like, and you have additional items, maybe going to an attorney might be what is necessary for you, but most people can use the medical durable power of attorney form that I'm providing, as not everyone has multiple people. Some people only have one person that would be able to support them in this area. So once again, the medical durable power of attorney is one of the most important documents because it guides everything else in our plan. So some considerations that you need to take before completing this document is having as many conversations as you need to ensure that the folks that you are considering as your agent or your alternates, that they know how they're going to support you, that they understand what you're asking of them, and also that they have the option to agree or disagree, right? If they don't feel capable of taking on this responsibility, please do not take it as somehow they don't love you or they don't support you. All of us react differently in emergency situations. Some people are very calm, cool, and collected, and some individuals fall apart. So consider that as you're determining who that person is. They don't have to be family. I recommend it's people that you trust, people that are available in case of an emergency, and in case of ongoing care. The other thing that I get asked quite often is, does my agent need to be in the same state as I am? And my response to that is always, it really depends on the agent and their resources. In case of an emergency, can they come to you? If you need ongoing care, will they be able to provide supports so they could advocate for you on a long-term period? So yes, they could definitely live outside of the state of Colorado, outside of your city or even your county, across the state from you, but just know that, do they have the resources? Can they get to you if you need medical care and you can't communicate? So let's move on to our next advance directive. So our next advance directive is the living will. And a lot of folks get confused with the living will because of the word will. So it has nothing to do with property. It has everything to do with what medical care you want at end of life. Okay, so we're talking still about medical care. This document is recommended for everyone over the age of 18 and at all health levels. So what does the living will do? It outlines what medical treatment you want in case of a terminal condition or persistent vegetative state. So you're really looking at end of life, okay? Your medical durable power of attorney is the one that looks at this document and knows what medical treatment you would want. Some things to consider with the living will is that there's two schools of thought when it comes to, do you need a living will, yes or no? So one of the schools of thoughts really say if you have an agent on your medical durable power of attorney that you've had the conversations, they know your preferences, they know they're well informed, you've had the conversations that lead to what medical treatment you want, don't want, they know what's going on with you medically, then at that point they're well informed, so they don't necessarily need a living will. Whereas the other school of thought really focuses on, you know, these documents are needed in a very stressful time. A living will allows you to document how you feel about medical treatment, and you could outline your preferences there. And this helps your agent to be able to follow the items that you outlined in that living will. So one of the things that the living will does is also talk about organ and tissue donation. Who do you want to be part of the people that get contacted when you're hospitalized? In addition to your agent, are there any other individuals that you would want medical staff to talk to them and keep them informed about your medical status? They don't have any decision-making capabilities, but they are able to talk to the medical staff treating you to see what's going on. So with the living will is really based on what makes sense for you and what medical treatment you want. So there's no right or wrong on whether you choose or don't choose to receive artificial nutrition and hydration or life-sustaining procedures, or if you want to be an organ donor. It's really what is meant, what is meaningful for you and how you want those last days to look like. So I do have a question that indicates what happens if there's a conflict between my preferences for treatment and Medicare / other insurances, parameters, and coverages for treatment. So that is a question mark at any point in our lives, whether we have advance directives or not. So one of the things that I recommend, and I think it's best practice, is before we ever complete any advance directives, that we talk to everyone that is our support system, family, friends, chosen family, our spouses, if we have children, our doctors, if we have any specialist or specialist, any religious leaders that we look up to, that we could get counsel from. Those are all people that we should be speaking to, in addition to insurance providers and such, because The advance directives are meant for you to have a plan, but they're not going to cover every single little thing that could happen under the umbrella of life. So at any point that there might be conflict between what insurance covers and your preferences. So if that is the case, and you already know beforehand that that is the case, I would recommend that you have a conversation with your agent in order to make sure that they understand what your insurances are, and that also there might be a conflict in what are the steps to take and what insurance coverages you have. So the other document that I want to cover is the 5 wishes, because I get so many questions about the 5 wishes. So the advanced care planning community has really moved away from the 5 wishes because there's some issues, and we'll go more into the issues with the 5 wishes. The way that you should be looking at the 5 wishes right now, it's a great tool to start conversations and to understand what your preferences are about medical treatment, but not necessarily complete it. So when we're talking about the 5 wishes is 2 documents in one. So it takes the medical durable power of attorney and the living will and makes it into one form. That is what the 5 wishes are. So if you have the 5 wishes, you shouldn't have a separate medical durable power of attorney and living will, because when you do this, whatever documents you completed first, you're voiding those, and the second set of documents are the ones that stand. So in front of you, you should be able to see option 1 or option 2. So you either have a medical durable power of attorney and a living will, or you have the 5 wishes. There is a cost associated with getting copies of the 5 wishes. Last time I checked on their website, it's I think it's like $5 to get 1 copy of the 5 wishes. So note that there's a cost associated with that, whereas the medical durable power of attorney and the living will, those are free documents. The ones that I'm providing for you today, when you go to an attorney, you do have the ability to get those customized. So instead of being 2 documents, it might be 1. So also note that. So back to the 5 wishes. So we want to make sure that you either choose one of the options. It's completely up to you if you want to choose the 5 wishes. But here are my considerations out why the Advanced Care Planning Society, not society, but world has basically stopped recommending for people to use the 5 wishes. And maybe not recommending, but has moved away from it. So in the 5 wishes, there's different areas where it'll ask you about medical treatment. So what happens there is you have the ability to write your preference and what that means. So when you're writing this, it can completely make sense to you. But when medical personnel are looking at what you wrote, they might be interpreting that in a very different way that you meant it or that you intended. So that is one of the areas of concern. Whereas if you take a living will, specifically the form that I'm providing you, it gives you very clear options. Yes, I want life-sustaining procedures. No, I don't want life-sustaining procedures. If you choose life-sustaining procedures, you could give a time frame. So you're very clearly saying yes or no. Whereas when you're writing it down, you could give different scenarios. And if those are not the scenarios that you're in, it's still not very clear if you want life-sustaining procedures, or do you want artificial nutrition and hydration? You have three options. You could say no, you could say yes and give a time frame or a goal, or you could say yes if it's advisable by the medical personnel that are taking care of me. So once again, the living will, very clear. No, yes, and I might have a time frame, or yes, but only when recommended by a medical professional. So once again, you have very clear yes or no's, whether you want a medical treatment, whereas with the 5 wishes, it's really based on what you write, how you write it, and how it gets interpreted. So that's why the move away from the 5 wishes. So the 5 wishes, it's still a wonderful tool to start the conversations so your agent and your alternates know your preferences, but it's more clearly documented in a living will. So once again, let me clarify. You either do option 1 or option 2. You don't have all of these 3 documents. You either have option 1, which is a medical durable power of attorney and a living will, or you have the 5 wishes. You do not have all of those 3. Let's say that you complete the living will and the medical durable power of attorney. You completed those last week, and today you complete the 5 wishes. By completing the 5 wishes today, you have made the medical durable power of attorney and the living will that you completed last week null and void. Okay, so if you don't want that to be what's happening with you, make sure that you choose either option 1 or option 2. The other advance directive that I want you to be aware of is the Psychiatric Advance Directive, also known as PAD. So this is recommended for everyone 18 years and older who are mental health patients. This is an advance directive that focuses on your specific needs. So what does the PAD do? It appoints an agent and alternates who can speak on your behalf if you need mental health treatment, medication, alternative treatment, your preferences and history in the event that you need any of those things and you lack capacity to make decision. So it also provides a lot of more other information. So preferences, you know, it's a 7-page document. It is very lengthy. So it covers everything from diagnoses, medications that have worked in the past, medications that haven't worked. It's a very specific and it's very detailed. So once again, this is for our folks that are mental health patients and that they also want to have someone who speaks on their behalf in the event that they lack capacity to make decisions and want to make sure that they receive specific treatment and what their preferences are. So understand that the PAD only addresses mental health, behavioral health services. So you would also need a medical durable power of attorney for your medical, and also consider the living will for end of life. One of the main things to note is that the PAD it is only effective for 2 years unless you update it. So that is one of the things that if you have a PAD, you need to make sure that you review. As best practice, I tell folks, review your documents every year. If you need to make changes, make changes. And if you don't, it's fine. But with the pad, you actually have to go ahead and execute a new form to make sure that it's still up to date. So in addition to the pad, you would also need, at minimum, your medical durable power of attorney to have someone that speaks on your behalf when you need medical care and you're not able to communicate. So let's go into doctor's orders. So remember, advance directives are all the documents that we're talking about today. The first four that we spoke about, they're legal documents, whereas the next two that we will talk about, they're actually doctor's orders. So the legal documents appoint or give power or say, this is the medical treatment that I want. Whereas doctor's orders really focus on what type of level of care am I going to receive. These documents need to be completed along with your doctor. And this is what makes it a doctor's order, because on there you're clarifying what type of medical care you want, and that is the level of care that you will receive across the board, okay? So who should be completing doctor's orders? So 18 years and over, again, the doctor orders that will cover, they're part of advanced care planning. So once again, like I said, Colorado is not a next of kin state, so this means everyone 18 and over needs to have in writing who's going to speak on their behalf. So doctor's orders don't document who's going to speak on your behalf. So you would still need a medical durable power of attorney to say, so-and-so is going to speak on my behalf if I need medical care and I cannot communicate. So doctor's orders work along with a medical durable power of attorney. So everyone 18 years and over who has decisional capacity, if an individual no longer has decisional capacity, they should not be completing any advance directives. At that point, family, friends, whoever the support system would have to seek legal guardianship and conservatorship or conservatorship. So the most common doctor's order that is out there is the medical orders for scope of treatment, the most form. So who can complete this form? Anyone 18 years and over. This form is only meant for individuals that are chronically and seriously ill. So if you're a healthy individual, this is not a form that is meant for you. It is specifically meant for chronically and seriously ill patients. And remember, you would still need a medical durable power of attorney, so you have an agent that is able to speak on your behalf. So what does the most do? It's a doctor's order for end-of-life care for chronically or seriously ill patients, okay? Once again, if you're healthy, this form is not meant for you. So medical staff, when you have a most form in place, medical staff, whoever they are, those are the orders that they will follow. Whatever's documented on that form, those are the orders that they will receive. This is why it needs to be completed between you and your doctor or an advanced practice nurse or physician assistant, okay? With that signature, that medical provider is saying, provide this level of care and only this level of care, okay? So once again, you need that medical durable power of attorney. So you have someone that could speak on your behalf. And anytime that there's a clarification needed on the level of care or anything else as far as medical treatment when it comes to end of life, the most refers people to the living will. So you could have the medical durable power of attorney, the living will, and the most. So that way there's clarification in care. So once again, the most form is meant for chronically and seriously ill patients, not for healthy individuals. And you still need other advance directives like the medical durable power of attorney and the living will. It needs to be completed by you and your doctor. Without your doctor's signature, that document is not effective. And there's no right or wrong with what kind of level of care you want, but it is very important that you understand what that means and you talk to your doctor about it. We've seen barriers to care when healthy individuals have the most form. One of the most common situations that we've heard at the society is individuals that completed a most form said they wanted comfort level of care, and they went in with the urinary tract infection, which is very treatable. However, they were kept comfortable and then released. So an unintended consequence of having a most form when you're a healthy individual can be exactly that. You could have a very treatable situation going on. You go for care, but because you have a doctor's order that indicate only this level of care, that's the only level of care that that medical staff will provide. So once again, our folks that are healthy, this form is not recommended for you. It's recommended for our chronically and seriously ill patients. And I will also provide a copy of this form in case this is a form that you need for your advanced care planning. The next is a CPR directive. A lot of folks call the CPR directive a DNR order or do not resuscitate order. When we're completing it with our doctor, it's a CPR directive. When you are admitted to a medical facility, it goes from a CPR directive to a do not resuscitate order. So that's why people get confused when we use the terminology CPR directive instead of DNR order. So essentially they're the same, but it depends if you're admitted to a medical facility or not. When you're in that medical facility, it becomes a do not resuscitate order. When you are not admitted in a medical facility, it's a CPR directive. So the CPR directive, what does it do? So it is also a doctor's order, but it's opting you from receiving CPR. So if you want to receive CPR, you do not have to do anything. These are for individuals that do not want to be resuscitated. Because the medical system works in a way that it's set up to keep us alive, you will receive CPR if you stop breathing or your heart stops. If that is what you want, then you do not need to complete a CPR directive. Let me note that again. Only individuals that do not want CPR to be resuscitated are folks that should consider the CPR directive. So a CPR directive is for anyone that doesn't want CPR. It's recommended for everyone 18 years and or older, healthy individuals. Remember, you still need a medical durable power of attorney to say who's going to speak on your behalf, and you should consider a living will. So why some folks choose the CPR directive is very simple. Let's say you have osteoporosis. Osteoporosis impacts your bone density, so it could be very easy for you to have fractures. So if you have CPR administered to you, it's very likely that you will never get back to the health level that you were before, because it would end up causing or might cause fractures, your ribs or other bones. So some individuals are also at different points in life where they might not want CPR. So if that is your case, then the CPR directive is what you should be completing. So one of the things to note, if you have a MOST form, you don't need to complete the MOST form in addition to the CPR directive, okay? The MOST form has on there a CPR directive where you indicate whether you want to be resuscitated or not. So if you already have a MOST form because you're a chronically ill patient, or you're seriously ill and you've decided to add the MOST into your advanced care plan, then you don't need to have a CPR directive in addition to the MOST. The MOST takes care of that piece. It's meant for healthy individuals where the MOST doesn't apply to them and they don't want to receive CPR. So this document needs to be completed between you and your doctor. That doctor's signature is what makes it a doctor's order. Okay, so that's what makes it effective. That's why we need the doctor's order. And this document, in order for you to not receive CPR, needs to be present at the time of need. So that means if you have a medical emergency, 911 is called, that document needs to be there so medical staff understand that you don't want CPR. So when we complete our advance directives, it's very important that we keep our the originals in a safe place, and then we have copies available. So if 911 is called, they know whether we want CPR, who's going to speak on our behalf, and basically what our plan is. So now we've covered the most common advance directives. Let's go into some different scenarios that might clarify why one person will choose certain advance directives over others. So let's see. Before we do that, I do have a question. Does the MOST form override my own decisions if I am available to make decisions? So anytime that you change your mind about the level of care that you want, you could go ahead and make changes to your advance directives if you're able to communicate. If you are not able to communicate, that's where it becomes difficult, right? So that's where having an informed agent really is the key. So that's why it's very important that if you have a MOST form, you exactly know what level of care you're getting, what treatments you're saying yes to and which ones you're saying no to. So that way, whatever situations come up, if you're not able to make your own decisions, your agent is able to speak on your behalf. And if your MOST form needs to be changed, you could request the change by talking to your doctor. And we have another question about CPR. So does the CPR form prevent electric shock to restart your heart? So CPR could be, you know, anything to resuscitate your body, whether it's compressions on the chest, whether it's a medication or anything else. That's what you are opting out to. So if you want to make it more specific, I would say talk to your doctor and see what that would look like for you. Because usually when you are opting out, you can't it's like being pregnant. Either you are or you're not. So when you're saying no to CPR, you're basically saying no to everything under the umbrella of resuscitation. So just note that. And based on your situation with your doctor, maybe that is a larger conversation where maybe the CPR directive is not appropriate, but you're looking more at a most. So just note that piece. I would talk to your doctor to make sure that that makes sense. All right. So let's go into the different case scenarios. I hope that this is of assistance to you. So as you're trying to figure out which advance directives to consider, you have an idea why certain advance directives are being recommended versus others. So here we have Martha. Martha is 55 years old. She has no major health issues, but she does have a mental health diagnosis, and she is seeking treatment for her mental health diagnosis. So the advance directives that Martha should consider is having that medical durable power of attorney. So she has someone to speak on her behalf for medical care. She should consider a living will for any end-of-life treatment. Because she has no major health issues, we're not recommending a most. She hasn't made any specific request that she doesn't want CPR. So that's why she's not considering CPR directive. And because she has a mental health diagnosis, she should consider the psychiatric advance directive. So let's go into another scenario. So here's Mark. Mark is 77 years old. He has several health conditions, including high cholesterol, high blood pressure. He has diabetes. And in addition to that, he was recently diagnosed with colon cancer, and he's going through treatment. So what advance directives should Mark have in place? First, we begin with the medical durable power of attorney. So he has someone that is going to speak on his behalf. You have the living will that outlines what medical treatment he wants at end of life. And he also has the most. Because he is seriously ill, and has chronic conditions, we want to make sure that he has the opportunity to complete the most. So as he is going through chemo, wherever he goes and receives medical care, it is known what type of level of care he wants and what level of care he should be receiving. So now let's talk about Max. Max is 65 years old. Max is a pre-diabetic and has osteoporosis. Osteoporosis is more common in women than in men, but it does happen in men. So what should Max be considering as far as advance directives? The first thing, medical durable power of attorney. So he has someone to speak on his behalf. He should also consider a living will to talk about end of life. And because he has osteoporosis and the damage that could be caused with CPR, he should consider a CPR directive if he doesn't want CPR. Now, he might want CPR, and that's completely okay, but that would be a conversation that I recommend that he has with his doctor or specialist to make sure he fully understands what it would look like if he receives CPR and what that would look like based on his health condition. So now we have Maggie. Maggie is 80 years old. She is the primary caregiver for 3 grandchildren. All of them are under the age of 18. She has some health conditions, excuse me, but she's managing those through exercise, diet, and medication. So she's overall pretty healthy. So what are the advance directives to consider in Maggie's case? Definitely the medical durable power of attorney. She has someone to speak on her behalf if she needs medical care and is not able to communicate her needs. She can consider a living will to talk about what medical treatment she would want at end of life. When we see individuals that are taking care of little ones or are the caregiver for someone else, those individuals should consider what level of care they want, whether they want CPR or not. For individuals that typically are a caregiver, they want to be there for those individuals. So typically they wouldn't have something that would say no to CPR. So that's why it's not on there, but definitely Maggie, if she does not want to be resuscitated, she could consider a CPR. But if she wants CPR and wants anything medically possible to be provided to her in order to continue to be the caregiver for her grandchildren, then at that point, she should also consider CPR. Although she has some health conditions, so she is somewhat healthy, she's managing those through diet, exercise, and medication. So she's not seriously or chronically ill, and that's why the most is not recommended for Maggie. As we covered before, the most form is for individuals that are chronically and seriously ill. So now that we have gone through different case scenarios, I wanted to give you some tools so you could kind of figure out where you would land if you were trying to figure this out by yourself. So the first question is, what advance directives should I complete? So the first question, and here's you, the first question that you should answer is, do you have a serious life-limiting medical condition? If your answer is yes, so this means you're chronically or seriously ill, then it's recommended for you to have a medical durable power of attorney, a living will, and a most form. If your answer is that you do not have a serious life-limiting medical condition, so you're healthy, overall healthy, or you have some medical conditions, but you're managing those well and it's not a major issue at this time, then the recommendation would be a medical durable power of attorney and a living will. So this is for you. You will have access to this. So as you are trying to figure out what makes sense for you, you have access to this. The other tool is CPR related. So do you want CPR? If you want CPR, then we don't have to do absolutely anything else. It's only if you do not want CPR that we want to answer that same question as we did in the previous slide. Do you have a serious life-limiting medical condition? If the answer is yes, so you're chronically or seriously ill, then we're recommending the most, and the most has a section for you to say whether you want CPR or not. If you don't have a serious life-limiting medical condition, then we're saying consider completing the CPR directive, okay? So that tool will also be included in the slides for you to be able to use. And let's talk about some best practices to consider before we complete any of the advance directives. So we're going to break it down in 4 different steps, as you can see in front of you. So before you complete any forms, take inventory of your medical needs and preferences. It's really important that you understand what your own preferences are, because there's no right or wrong. It's just what makes sense for you. So whatever those preferences are, we want to make sure that you understand what those look like, and you have the conversations that you need to have with whomever. So once you take inventory of your medical needs and preferences, that's when we get to identify what forms make sense for you. So is it the medical durable power of attorney, the living will, the psychiatric advance directive, the most form, the CPR. So if you don't want CPR, then it's important that that is listed as part of your preferences, so that way you could know which forms you need to complete. The next step is to have conversations. Before completing any forms, we want to make sure that you have conversations with the persons you are considering as your agent and your alternate. Your alternates, we want to make sure that when you are looking at agents and alternates, that it's people that you trust, that people that are available in case of an emergency, or if you need long-term care or support, and that this person understands those preferences, and that they're going to advocate for you based on your preferences and not their own. So the conversations, although here I have listed your agent and alternates, make sure you're completing everyone else that is part of your support circle, whoever that is, whether it's doctors, religious leaders, anyone that is of support to you. And once again, your agent and alternates, they do not need to be blood related. It could be anyone that you trust, and they need to be obviously adults in order to serve in this capacity. So now that you know your preferences, you know what forms you want to complete, let's talk about what information you need. So the information that you need for your forms will typically be your own personal information, so your name and such. So you need to know that. But in addition to that, you need to know your agent and your alternates information. So their full name, telephone numbers, if they have an email, and full addresses. So note that for telephone numbers, we also want the full telephone number, including the area code. And for you to be able to know what your end of life preferences are. So now that you've now that you've basically taken inventory, you've had conversations, you have the information that is needed, then you can move into completing the forms. And in this webinar, I didn't go into much detail about what each form needs to be completed. Please watch previous webinars on how to complete a medical durable power of attorney in a living will in order for you to have all those details. So that way you know whether you want to notarize it or not, and how to step-by-step complete those 2 forms. In my follow-up email to you, I will make those available, those recordings available. And also, if you are going to complete either the most form or the Cpr directive, understand that you need to do that along with your doctor. So making the appropriate appointments with your doctor to be able to do this. Medicare does cover a free consultation for you to go with your doctor and complete these forms. So once you've completed your medical durable power of attorney and your other advance directives, you always keep the originals yourself, and you provide copies to your agent, your alternates, and your doctor. The other thing is we want to make sure that these documents do not stay in a box that no one knows about them. We really want these documents to be live documents. So we really do recommend that you review them every year when there's a change in condition, when there's a new diagnosis, when there's marriage or divorce, or if you change your mind about who your agent is or your alternate or your medical treatment that you prefer. Those are perfect times. Specifically for divorce, I do want to make a note that if your ex-spouse is named as your agent, as soon as there's a divorce decree, your medical durable power of attorney becomes voided. So you would need to complete a new medical power of attorney after a divorce decree if you named your ex-spouse as your agent. So the resources in front of you, I will include those. They will be clickable items, so they will take you directly to the source. And oh, I am so sorry. Let me go to the end page so that way you could go ahead and see my contact information in the event you want to get a hold of me. So we are at time, but if you want to stay with me, I will make sure that I answer your questions. So let's see which questions I haven't answered. So you've mentioned legal representation several times. If we can't afford one, if no help is available, can this be avoided, or do you absolutely need an attorney? So all the forms that I'm providing you in these webinars are forms that you can complete yourself without the need of legal representation. It's when you want to go above and beyond what these fill-in-the-blank forms can provide that you would need to seek legal representation. At the Society, we do provide assistance to help you complete these forms free of charge, so that way that isn't a barrier for you. Excuse me, that's not a barrier for you to complete your advance directives. And let's see. Okay, I completed a most form with my doctor. If I want to withdraw it, what do you do? Do I need to withdraw it from the hospital as well? Do you refer to an organization that helps guide you in information? What is the name? So if you email me or call me, here's the information in front of you. I am more than happy to help you through your advanced care planning journey. You could change the most at any time. You just need to contact the different medical institutions that have a copy and let them know that you would like to withdraw it, so that way they could go ahead and do that. You could go, and if you just need to amend it, you could talk to your doctor, make the amendments to the most form, get your signature on it, get their signature on there, and update it. So you can change it at any point or withdraw it. It's just a matter of contacting those different medical organizations and making sure that they withdraw it. So why would Mark need a most form if he has the medical durable power of attorney and a living will in place? So the most form is for seriously ill and chronic patients. So The reason why he should consider a most form is due to the new diagnosis of colon cancer. Because it is a serious illness. He's going through medical, through treatment, in addition to the other issues he has, like diabetes, high blood pressure. In order for him to get consistent levels of care wherever he goes, a most form would facilitate that. So just remember, advance directives are not required of any of us, but they are tools that are already set in place for us to create a plan. So he doesn't need to complete a most form if he doesn't want to. It's recommended based on what his health condition is, that it went from having some, chronic illnesses to now having something more serious, which is the chronic, the colon cancer. And with that, okay, so we do have one more question. I just learned that Medicare covers office visits with physicians to discuss advance directives. I don't think many people know of this. Do you know if physicians are offering this, and if not, how do we get them to initiate the discussion so more people have these forms completed? So that is a huge question, because Medicare has covered that for several years now. However, depending on whether staff are trained to have these conversations or not with their patients, that is a big question mark. So there's several barriers to this. Is your doctor trained to have these conversations with you? Not everyone is prepared to have these conversations, so it makes it difficult to approach these conversations, and most of the time they're only being talked about when we're at end of life or an emergency has happened. So there's ongoing efforts to address exactly what your question is. So unfortunately, there's no one particular thing. It's many things that need to take place. What COVID-19 has done is put these conversations once again in the forefront of people's minds, because at minimum, like I said before, we all should be having in place that medical durable power of attorney to at least have someone that speaks on our behalf. And because medical staff don't have the training, sometimes that's the reason. Other times, this is seen as only a legal professional could assist. So if you don't have that connection to a legal professional, I can't complete them. But advance directives are not this huge monster. This is why at the society, we want to make sure that you use this resource, that you use this as a resource to ensure that if you need to have those in place, that cost is not a barrier for you to complete your advance directives. So I know that I didn't necessarily answer your question, just because it's an ongoing issue that that needs to be addressed, and that those of us that are part of people advocating for advance directives, and for this to be something normal, that it's not seen as we just need this because we are old, or we need this because we are dying. No, we need this because we don't know what the future holds, and whatever it holds, we want to have a plan associated with it, whether we are a young parent, whether we're in our 90s, as long as we're 18 years and older, we should be having these conversations and looking at these documents. So thank you for your participation in